Enniskillen Courthouse retains the arch under which prisoners once arrived by horse-powered vehicles, though these days it's much too small to allow modern prison service vans to access the courtyard. The courthouse is used as a hearing centre on 3 days a week. A magistrates' court is the venue for the first hearing of any criminal case, from the most serious, such as murder and rape, down to those which may see the defendant walk free with a fine. Most serious offences are subsequently heard at Crown Courts. There is no jury in a magistrates' court. The decision of the district judge is final. A Brookborough man who was caught driving home from the pub after having a few drinks has been disqualified. Judge McSorley disqualified him for a period of 12 months and also imposed a £250 fine and a £15 offender levy. An Enniskillen woman who punched her ex-partner in the face several times has been sentenced. District Judge Alana McSorley said that while the case wasn't clear-cut, she was imposing a restraining order in favour of the injured party and a £150 fine for assault. An irate man who was caught driving on defective tyres told police, "Take me to court, I don't care." District Judge Alana McSorley imposed 3 penalty points and fines totalling £225. A Lisnaskea woman who stole up to £300 worth of food and cleaning products from Lidl has been sentenced. For theft, the judge imposed a 2-month sentence, suspended for 12 months. For driving without a licence, she was fined £100. For no insurance, a 2-month suspended sentence was imposed. And to put all that into perspective, let's have a look at figures that apply province-wide. Over 30,000 defendants were dealt with in the magistrates and youth courts combined, with a conviction rate of 79%. That's according to figures from the Public Prosecution Service for Northern Ireland for the financial year 2023-24. There's a distinct contrast between the next 2 sets of bar charts. The gender of suspects on files received by the PPS is principally male. Just over 3/4, 76%, were recorded as male, whereas the gender of victims is mainly female. Almost 6 in 10, 57%, were recorded as female. There's a striking similarity in the final pair of bar charts. The age of victims on files received by the PPS is dominated by the 26 to 35 age range. It's 24% of the total. The largest proportion of suspects also lies in that age range, 30%. Back to Fermanagh. Time now to find out what lies behind the facade of Enniskillen Courthouse. Following security checks, defendants may decide to wait in the lobby and discuss matters with their legal representative. The building is Grade B listed, and this ceiling doesn't disappoint, with decorative plasterwork and elaborate chandeliers. We're in Courtroom 1. Designated a magistrates and Crown Court, it's also used by coroners. The public are not normally allowed entry to coroners' hearings unless they've been invited to participate in proceedings. Courtroom 2 is much busier. It's used as a magistrates, youth and domestic court. 3 rows of seats at the back constitute the public gallery. Witnesses and, depending on circumstances, defendants may also sit here to listen to proceedings until called forward to be questioned and give evidence. Both defence and prosecution lawyers test the credibility and reliability of the evidence their opponent presents to the court. Sitting with their backs to the public are the defence lawyers. Prosecution lawyers occupy the next row in front. Court clerks sit directly in front of the judge, along a row raised to facilitate greater visibility. They support the judiciary in the administration of justice and capture, for the record, all directions and orders of the judge. That glass-walled enclosure you can see to the left is the dock. If a defendant has been remanded in custody before the hearing, they may be escorted by prison officers from the court's holding cells to sit in the dock, with security staff seated behind the defendant. Otherwise, a defendant in custody may appear via video link on the screen to the right. The left screen is used to display documents produced as evidence. A defendant who's been waiting in the lobby will be called into the courtroom when their case is ready to be heard. Depending on the circumstances, they may sit in the public gallery to listen to proceedings, or they may be asked to go into the dock if they're on bail on the charges before the court. If they've entered a plea of not guilty and the matter is being contested, they may give evidence on their own behalf. In this instance, they may leave the dock or move from the back of the courtroom to the witness box, where they may be asked to repeat after the clerk either an oath or an affirmation. The phrase Almighty God in the oath is adapted to accommodate different religious beliefs. Alternatively, the defendant may choose to repeat after the clerk the wording of this affirmation. Perjury is the offence of wilfully telling an untruth or making a misrepresentation under an oath or affirmation. Others who may take oaths or affirmations include the PSNI, witnesses, and anyone giving evidence. Witnesses usually appear voluntarily in court, and there's no onus on a defendant to attend in person if they have a legal representative who can speak on their behalf. However, if the defendant is on bail on a charge sheet, a summons like this can be issued to compel a defendant to appear in court. Failure to appear can result in an arrest warrant being issued. A soundproofed cubicle in the court building allows solicitors to speak to clients in prison by video phone prior to their appearance in court. They may need to discuss how cases are progressing, any implications arising from available reports, or whether they need to see a probation officer. Probation officers sit here during court proceedings, while the next section is occupied by journalists and security staff. The job has exceeded my expectations. It's challenging and rewarding in equal measure. The jurisdiction of the Magistrates' Court is broad and varied. The importance of coming to a reasoned, logical decision is not to be underestimated. The Magistrates' Court is a busy place, and it's important to get work done as efficiently and diligently as possible to ensure that adequate time is available for the hearing of any contested cases. The most difficult part of the job is becoming comfortable in the unknown. Cases can change from what they first appear. That's why it's important to remain open-minded. The role requires focus and diligence, and the ability to be adaptable. Independence of mind, conviction of character, resilience, and good communication skills are essential. I have 2 teenage sons, and overall the job has provided me with a complementary work-life balance. Law in the United Kingdom is divided into 2 types. Criminal law deals with offences against society, such as murder, theft or assault, and the state prosecutes these crimes, imposing penalties like imprisonment or fines. Cases typically begin in a magistrate's court and can then be passed up to the Crown Court. Civil law deals with relations between individuals, for example when getting divorced, renting a house, or debt. It's about correcting wrongs, either with compensation or by directing parties to take certain actions as remedies to breaches in the law. Typically the police are not involved in these cases. County courts deal with civil actions, with the High Court hearing any complex or important cases. So here are the key comparisons. Criminal law aims to maintain order and deter future crimes, while civil law focuses on resolving disputes between individuals. In criminal law, penalties might include prison, fines or community service, whereas civil law focuses on compensation or directing remedial actions, such as removing gates that block public rights of way, removing buildings that don't have appropriate planning permission, or the return of property that was not paid for. Criminal cases are brought by the state, but civil cases are initiated by private parties. Criminal law requires a higher burden of proof. It must be beyond a reasonable doubt. In contrast, civil law requires proof on the balance of probabilities. That means more than a 50% probability that the defendant is liable. Criminal law decisions are given as guilty or not guilty, while decisions in civil law are given as liable or not liable. The defendant can appeal a decision in criminal law, and the Public Prosecution Service can appeal a sentence which they believe to be too lenient. The PPS can also appeal a decision to grant bail to a defendant if they feel there's a risk of harm to the public. In civil law, either party can appeal a decision. In Northern Ireland, it's the Public Prosecution Service that will take criminal legal proceedings against someone. The PPS will decide to prosecute if there's enough evidence for a reasonable prospect of a conviction and it's in the public interest. In a criminal court case, custody means detained in a police holding cell or in prison. When a person is charged with a crime and held in police custody, they must be brought to the first available court for the court to decide whether they should continue to be held in custody. Remanded in custody means being sent back to continue detention, but this time the defendant is taken to prison, not back to a cell within the police station. A custodial sentence means that the sentence will be served in prison if the offender is an adult over the age of 21. For a young person between the ages of 18 and 21, this will be in a young offender centre. For anyone up to the age of 18, this will be in a juvenile justice centre. Instead of being remanded in custody, a defendant may be released on bail until their trial date. Before they're released, they may be asked to surrender an identification document, such as a passport. A surety may also be asked to act as a guarantor, and as such may be asked to lodge money or valuables to secure the release of the defendant. If a defendant breaches bail, the judge may direct that the bail money is estreated, at which time the bail money becomes a fine that must be paid by the defendant. It's not the job of a judge to make laws. Laws are made in Parliament. The judge interprets and upholds the law. The jury is a group of 12 people chosen at random who hear evidence presented in court and decide if the accused is guilty or not guilty. In a magistrate's court, it's the judge, and the judge alone, who makes that decision about guilt or innocence, because there's no jury in a magistrate's court. A judge or jury will determine guilt or innocence based on the evidence presented at trial. After a defendant has been found guilty, a pre-sentence report will typically be ordered. It's prepared by staff from the Probation Board for Northern Ireland and is used by the judge to help decide on an appropriate sentence. A pre-sentence report may assess how dangerous the offender is, their risk of harm, the nature and causes of the offender's behaviour, their personal circumstances, and any factors helpful in considering the offender's suitability for different sentences. Probation officers are qualified social workers. In addition to working in court, they work in local communities, supervising any sentences that must be served by an offender in the community. They work in prisons, preparing prisoners for release. Some prisoners may only be released if they agree to certain conditions. They also work directly with victims of crime, providing support through the Victim Information Service. If we look at magistrates' courts across Northern Ireland in 2023 and analyse the type of penalty imposed following a conviction, the vast majority involved fines, almost 60%. Suspended custodial sentences account for 15.8%. 12.2% of convictions resulted in imprisonment, while community sentences accounted for 9.4%. Sentencing guidelines were developed to promote consistency in decision-making by the courts and to provide greater transparency of justice. A judge will begin by assessing the offender's guilt and the harm caused by the offence. This allows a sentence starting point to be reached. Prosecution lawyers can highlight aggravating factors that may justify an increase in the sentence. The judge must then listen to what defence lawyers propose as mitigating factors that may decrease a sentence. Across Northern Ireland in 2023, the largest proportion of prosecutions in magistrates' courts involved motoring offences, 46.4%. So let's look at sentencing guidelines for a specific offence, driving with excess alcohol. The maximum sentence involves 6 months imprisonment or a £5,000 fine or both, disqualification from driving, endorsement of a driving licence and 3 to 11 penalty points. The starting point and the sentencing range depends on the level of alcohol that was detected in the offender's breath, blood or urine. Examples of possible aggravating factors include being involved in an accident, The location, for example near a school, a high level of traffic or pedestrians in the vicinity, driving a heavy goods vehicle, poor road or weather conditions, or carrying passengers. Examples of possible mitigating factors include a genuine emergency, spiked drinks, or a very short distance driven. If a defendant is found not guilty by a magistrate, jury or judge, they're acquitted and free to leave the courtroom. This means the prosecution has failed to prove the defendant's guilt beyond a reasonable doubt. If a defendant is under 18 years old when they were prosecuted, their case is dealt with in a youth court and the public is not normally allowed access to watch proceedings. The purpose of an inquest is to establish the medical cause of death and to answer 4 statutory questions. Those questions are who the deceased was, when, where and how they came by their death. A coroner also has the responsibility for identifying any issues which may prevent further deaths. Coroners in Northern Ireland can either be barristers or solicitors. They're appointed as independent judicial officers available to conduct inquests. An inquest is an inquisitorial process, a fact-finding investigation. It's neither a civil nor a criminal trial. A coroner is prevented by the law from expressing any views on civil or criminal liability. An inquest may be held if there is reason to suspect that the cause of death is unknown, or the death was violent or unnatural, or the deceased died while in state detention, or the death was by misadventure or unfair means, or death through negligence, misconduct or malpractice, or caused by natural illness or diseases where a doctor hadn't seen or treated the person within 28 days of death, and such circumstances as may require investigation.